No. Yeah, we're waiting for you to bring in the donuts, Steve. He brought coffee for himself, but no donuts for anybody else. No. All right, try again. Good morning, everybody. Morning. I'd like to call the Will County Board Committee of the whole meeting to order at 9:33 a.m. If we could all stand for the Pledge of Allegiance. And I would like to invite Mayor Schumacher. Would you like to lead us, please?
Pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Mayor. Can we have a roll call, please?
Okay, here we go. Richmond. Williams. Dean Schlappman. Dean Schlappman. Ogala. Pretzel. Pretzel. Butler. Butler. Newquist. Balich. Oxley. Brooks. Winfrey. Bullock. Logan. Logan. Freeman. Revis. Revis. Mitchell. Mitchell. Ortiz. Berkowitz. Hickey. Costa. Costa. Trainier. Trainier. Van Dyne.
Present.
We have a quorum.
We do have a quorum. Thank you. Looking for a motion to approve the minutes, 26-5160, Committee of the Whole, the Strategic Plan Workshop in July 13th. Motion Williams, second by Winfrey. Any discussion on the minutes? Roll call, please.
Richmond. Williams. Ogala. Newquist. Balich. Oxley. Brooks. Winfrey. Bullock. Freeman. Ortiz. Berkowitz. Hickey. Van Dyne.
Yes.
Motion passes.
Thank you. Looking for a motion to approve 26-5230, Committee of the Whole minutes with the Will County Land Bank, July 14th. Motion Freeman, seconded by Hickey. Previous by Winfrey, seconded by Oxley. All those in favor, please say aye. Aye. Anyone opposed? That motion will carry. Now I'd like to invite the public comment section of the agenda. Is there anyone from the public wishing to speak this morning? Seeing none, probably because they didn't have their donuts and coffee this morning, Steve. All right, moving on. We do not have any old business, so we'll move right into new business. 26-5258, discussion, tax sale legislation, Public Act 104-0553, House Bill 4537. I need a motion to put that on the floor. Motion by Balich, seconded by Hickey. At this time, I'd like to invite Mr. Scott Piles, with the State's Attorney's Office, to start off the discussion. Good morning, Mr. Piles.
Morning, Mr. Speaker. Thank you very much for having me here today. So the last couple of years have been a very interesting change of events with regard to how property taxes are handled, how they are collected, and what happens once a property goes to a tax sale. So the United States Supreme Court in 2023 put forth a case that kind of changes in a significant way how properties are handled once they go to a tax sale. The Illinois legislature has followed up that Tyler decision with sweeping property tax reform legislation that was just signed in July. I have been working with the treasurer's office and members of the clerk's office regarding some of these changes. And I want to talk to you today about what the county board and what the county is going to have to do, in my eyes, to help alleviate, which could be a pretty significant problem. So first off, the county, the school districts, the fire protection districts are essentially funded in large part by property taxes. Those are taxes that are paid based on the assessed values done by the supervisor of assessments. And it is sent out in the form of a property tax bill that is payable typically in 2 payments. That money is then collected and it is distributed by the treasurer's office to all the different taxing bodies, including the county, which is a taxing body, the school districts, fire protection districts, and so forth. So these property taxes are then collected and they are distributed. And this is the money that our municipalities, our school districts use to fund their operations and their obligations to the public. And property taxes are a very important part of that puzzle. The property tax collection system is governed by the Illinois Property Tax Code. Some of the things that I'm going to talk about today and some of the problems that have risen are directly as a result of how the legislature has set up the property tax collection system. So prior to the changes in property taxes to 104.0553, property taxes were collected in kind of the following form. So the property taxes are collected by the county treasurer. Those property taxes are paid by the property owners. Now, some of the properties that we're going to be talking about today are generally not going to be impacted. Those with a mortgage, the banks typically, as part of an escrow account that the mortgage holder, property owner has, it's the bank that pays the property's taxes. So most people that have mortgages and own homes are not paying these property taxes directly. These are being paid by their mortgage company. So they don't see or realize the impact of sometimes the property taxes. They get the bill, the mortgage company is going to take care of it. Usually there's an adjustment in your escrow account if the property taxes go up. And that's really how you get the impact of that, because your mortgage payment goes up a little bit to account for the increase in the taxes or the amounts required in the escrow account. Now, there are situations where people do not pay their property taxes. Now, where we typically see that is people that own their own home. They don't have a mortgage, or they bought it with some other aid, and they physically go to the treasurer's office to pay the property tax bill. However, each year I would say there is not a significant portion, but there's quite a few number of people that do not pay their property taxes. Now, municipalities, the school districts, the county, we have to have the money that we're expecting in order to pay our employees, to take care of our obligations that we have to the public, the municipalities, the school district got to pay teachers. So the property tax code provides a system that allows money to get to cover the people that don't pay their property taxes, and that's a device called the annual sale. So as many of you know, I was in private practice. I knew nothing about how this worked until I started working with the state's attorney's office. So each year, it's been my job to go into court around Thanksgiving and ask the court for permission to allow the treasurer to put up all of the properties that have unpaid taxes to allow them to go to the annual tax sale. And how this works, once the judge signs off, we have to print a very large newspaper notice of all the properties that didn't pay their taxes and that we are going to put these properties in the tax sale. It is a laborious process that we do every year because we got to get the individual notices from each of the newspapers to show that we in fact notified through publication that we were doing this. So the court signs off on this process. 5 days later, the treasurer then holds a tax sale. Private tax buyers come into the private tax sale and they purchase tax certificates. These certificates give the tax buyers two outlets. The first outlet is if the property owner didn't pay their taxes, they come in and redeem. And they have, under the old law, they had 30 months to pay and redeem their taxes. And then they would keep their property. What would happen then is the tax buyer would receive that money, and the money that they paid for the tax fund or the tax certificate would be refunded to them. The benefit to the taxing bodies is that when the tax sale revenues come in, that gets distributed to all the taxing bodies to help fund their operations. That makes up for the fact that some people didn't pay their property taxes. So that process, the treasurer holds the annual sale. The tax certificates are sold to the private tax buyers. Now, those properties that do not get a bid or do not have their tax certificates purchased, those go to our Will County trustee. And we have representatives from Joseph Meyer here today. Neil Wallace, the general counsel, and Whitney Strohmeyer, the agent, that are here because they're going to play an important part of the role in one of the recommendations that we have for you today. So and the properties that go to the trustee are typically what we see retention ponds and condos. They're usually a pin where there's a retention pond. Nobody really cares about it. The taxes don't get paid. Those go to a tax sale. Somebody unwittingly may buy it, realizing it's essentially a worthless piece of property. And then it goes on from there. But the private tax buyers buy the bulk of them. And then the properties that are of not as much value, those end up going to the trustee. And he administers them in a very similar way to the tax buyer. And we'll talk about that a little bit later. So if the property owner redeems their taxes, the tax buyer gets a refund. However, if the property owner does not redeem the tax certificate within the 30 months, the tax certificate is essentially a ticket to allow the tax buyer to go to court and to petition the court to give them a tax deed for that property. That's how the property tax code is set up. It was an incentive back then to bring the tax buyers to the table to essentially give us money to fund all the governmental operations. And then if the property owner never redeemed, at the end of the day, the tax buyer could get title to possibly a valuable property. Now in Illinois, we have what's called the indemnity fund, and I don't know if I've ever talked about any of those. The indemnity fund is also set up in the property tax code as kind of a relief valve for property owners that lose their homes in a tax sale. And the property tax code is set up to allow these distressed homeowners that lose their property to come in and file a claim with the treasurer and say, we lost our home, we want to make a claim under the indemnity fund. The indemnity fund is, in essence, funded by fees paid by the tax buyers when they participate in the tax process. So it's kind of, to a certain extent, is self-funding, but in some ways it's not, because if there is an overwhelming number of claims, the fund can get depleted relatively quickly. Here in Will County, we've been able to stay ahead of the curve on some of the indemnity claims because as part of my job at the state's attorney's office, I handle the indemnity claims. And as part of that, I talk with some of the people that have lost their homes. It's generally a situation where they usually own the home free and clear. And sometimes it's quite valuable. We might be talking about a $300,000 or $400,000 home that these people lost because they couldn't pay a $20,000 or $30,000 tax bill. That's quite a hit. So generally what I see when we do these indemnity cases, typically they own a home and then something befalls them. They have a workers' comp where they can't work, or they lose their job, they fall behind. And the property tax bill typically falls at the bottom of the list of bills to be paid. But eventually, as the process goes forward, the amount to redeem grows because property taxes become due the next year. There are penalties, and there is also interest awarded to the tax buyers in the bidding process. Oh, thank you very much. So we're still, is my voice not carrying? I generally don't have a problem with my voice, but I guess it's being recorded. So the difficulty here is that the people that lose their homes in this tax sale process are generally not on the right side of things as it is, and then they lose their home on top of it. So when the tax buyer takes deed, they get the property and they get the full property, and then they can go and sell it. They can keep it and rent it out, whatever, but they get the benefit of the property when the property owner does not redeem and the time has expired. So the county does not get any surplus from any of these properties. That money goes directly to the tax buyer. So, and in 2023, the case of Tyler versus Hennepin County, Minnesota is decided, and this kind of really sent a shock wave through the system. So what happened in Tyler, Geraldine Tyler was a 94-year-old pensioner who had a $40,000 condominium, and she did not pay her $15,000 in taxes. And she lost her home, her condo. So she sued, saying it was an unlawful taking. So under the Fifth Amendment of the Constitution, there is a clause in the Fifth Amendment that says that we cannot take private property without paying just compensation. So Ms. Tyler said, Hennepin County took my property. I owed $15,000 in taxes, but I ended up paying $40,000. I lost my condo and I lost all the equity. So the United States Supreme Court heard the arguments in this case, and they held that the seizing of Ms. Tyler's condo for the entire $40,000 was an unlawful taking, and that the $25,000 that she lost, that she did not owe in taxes but went to the county, was a unconstitutional taking under the Fifth Amendment. Hennepin County was liable to that homeowner for the lost $25,000. So this decision comes down, and here we are in Illinois. We're not even taking the surplus, but we are taking the properties for these unpaid taxes. If you think about it, we got kind of the worst of both. Not only are we doing the taking, but we're not even getting the money. The money is going to the private tax buyers. They're collecting the surplus in the properties. We're not even taking that. We're just getting the taxes. In the Tyler case, Minnesota was at least getting the surplus. We're not even under the Illinois property tax code as it existed. We weren't even getting the surplus. So after the Tyler case, some of the same lawyers that were involved in the Tyler case filed suit here in Illinois in a case called Sherritt versus Henry, and that's up on the board there. So in Sherritt, that is a class action lawsuit naming all people in Illinois that have lost their home in a tax sale and did not receive payment for the equity. So far, that case is kind of in the pleading stage. Some of you may be asking, well, and Will County is a party in that case, and we have outside counsel along with myself involved in representing the county in that. we've raised some arguments in the federal court cases. Well, wait a minute. You know, Illinois is not like Minnesota. We don't keep the surplus. The private tax buyers do. The court said, doesn't matter. The county is the one doing the taking. We're taking the property. We're committing the Fifth Amendment violation. So what we've done and we've tried to do is we've tried to third party in, which essentially bring into the case the private tax buyers to say, hey, okay, if we owe this money, they're holding it. They took the money. So far, the federal courts have said, no, we're not going to allow these third party actions because number one, there are no contribution claims. And when I say contribution claims, there's no requirement that a private party aid in paying for a constitutional violation that's being committed by a defendant. That ruins the deterrent effect of a Section 1983 action. Section 1983 is a civil rights violation. We've been in here and talked about those in executive session. These are cases for violation of civil rights. So because these takings are considered to be 1983 actions, we haven't had a lot of success in the Sheriff versus Henry case of bringing in the private tax buyers to help aid in this liability that the Tyler versus Henneman case has put upon us. There was also another case that's pending in federal court involving Cook County. That's Kidd versus Pappas. And in that particular case, the federal judge has said that the Cook County treasurer is violating the Fifth and Eighth Amendment rights of the property tax distressed homeowners by taking their property. So essentially, Cook County is going to be on the hook for all the properties they've taken and not resupply the surplus. Now, there hasn't been a damages assessment yet in that case, but these are some of the federal court cases that are pending regarding Tyler that are active here in Illinois. So as a result of Tyler, the Illinois legislature passed sweeping property tax reform that now protects the surplus of the homeowners that lose their property in a tax sale. And they've kind of changed how the property tax system sale process works. And it's going to require action by this board and some of the county officials to help implement it. And that's part of why I'm here to talk about this today. And I understand this is, I mean, I'm probably talking a little bit above, but you know, and I'm here to answer any questions that people have afterwards. And that's why we have the treasurer and the county tax agent here to answer any questions you may have based on some of the recommendations I'm going to make at the end of the presentation. So the legislation that was passed changes the way the property is transferred. Instead of a direct title transfer to the tax buyer at the end of the redemption period, now a tax buyer or the trustee now have to apply to the court for permission to hold an auction. So instead of the tax buyer just getting the property, now they have to go to court and they say, well, we want to place this property up for auction and allow bidders to come in and buy it. Now, this will help in a couple of ways. Number one, it'll help assess what the true value of the property is in order to determine what the equity loss is. And number two, after this auction is held, the statute requires that any surplus after the payment of the taxes and the penalties and the interest, the surplus from that sale must be deposited with the treasurer to allow the former homeowner to make a claim for it. So now, instead of them losing their home, now they're going to get the money, the surplus after the auction. And this is a publicly noticed auction. People can show up, banks, private individuals, other tax buyers can come, and they can bid on this property, and the highest bidder gets it. Now, there's a minimum bid set for these auctions. The minimum bid covers any taxes and interest that are currently pending, and the surplus would rise as people go higher and higher in the bidding. Then that would create the surplus that would be deposited with the treasurer. Now, some of you may be thinking, well, then where do the tax buyers? Tax buyers can still theoretically make some money on the interest and some of the penalties they're assessed by making the late payments. Because interest goes up every month that the property taxes are not paid, and that interest goes to, in some instances, the tax buyer, correct? Yes. So the legislation now protects the homeowner surplus. In addition to that, it also allows, part of this was already in the legislation, it now allows a county, if they decide to become the owners of all of the depressed or distressed properties in Will County. And when I say the owner, essentially all the property, instead of just the bad ones, could go to the Will County trustee. They would become the tax buyer, and then they would wait for the redemption period, which is now 3 years under the new legislation. They would wait for the redemption period to go. They'd be the technical tax buyer. And at the end of that 3-year time period, then the trustee would put the properties up for auction. And once the amounts were determined and there was a surplus, then that surplus would be deposited by the trustee with the treasurer for the former homeowner to claim the property. So the winning bid at these auctions covers the taxes that are owed, the penalties, and the interest, and then the money above that minimum amount would then be the surplus that would be deposited with the treasurer. The legislation also sets up what's called a surplus equity fund. And what this fund does is this is to cover properties that weren't covered by the new legislation. And we're talking about properties that have already went to tax deed and outstanding tax sale certificates that are out there. So people that have private tax buyers are holding certificates and they do not redeem, they could make a claim under this surplus equity fund. And the surplus equity fund is funded in part by fees paid by the tax buyers when they participate throughout the taxing process. There's a $500 fee if they take a deed. Every time they make a payment, there's another charge. The legislation also allows the treasurer, if you so approve, a $20 fee every time there are certain payments made to the clerk or the treasurer's office with regard to these properties. And then this money is going to help accumulate funds so that we can pay claims under the fact that there's some people out there that have lost their home and the title, and they can make a claim against the county for the loss of their equity. Now here's the kicker. So in this bill, there is paragraph E that's part of section 21-302, payments of the surplus equity fund. If the surplus equity fund does not have sufficient funds to cover any surplus equity award ordered pursuant to 21-302, which is essentially the person making a claim with the court saying, I lost my equity. I want to make a claim against the treasurer in the county for the loss of my equity in this home. And the court says, yes, bang, here's the award. And then they make a claim against the surplus equity fund. If the surplus equity award ordered pursuant to section 21-32, the county shall fund the balance necessary to satisfy the unpaid surplus equity award pursuant to section 21-32 within 12 months of the date of the court order awarding the surplus. So the legislation has now put it on us. If the surplus equity fund does not have enough money to pay off an equity award, it is up to us to fund this money. Now, Moni probably are sitting out there, well, wait a minute, this is really kind of unfair. We didn't even get the surplus in the first place. I get that. This is a mess. So at the bottom of this slide, now we're going to look at the kicker. So currently, according to the Treasurer's Office, we have 75 to 80 tax deeds that have already gone out, which means 75 to 80 people have potentially lost some equity in their home. On top of that, we have 2,000 outstanding tax certificates out right now, which means this is 2,000 opportunities for us to have to pay a loss of equity. Now, the good news is the great majority of these are going to be redeemed. Most people that are in this situation come up with the money, and some of you might be thinking, well, wait a minute, why can't they just go out and get a home equity loan, come and pay the taxes? You know, that's a question I ask in a lot of these indemnity cases. Why don't you go to the bank and get the money? You have $250,000 in equity in your house. Go get a loan. You know, the answers to those questions are not, not really prevailing, but either they're not working or they don't think that they can get a loan or they're confused by the process. A lot of them do not go to the bank and get the money to redeem the property. But out of that 2,000, we would estimate that probably 90% or about 1,800 would probably redeem, leaving maybe 100 that are out there that may do that. And we're going to talk about that because we have a solution to that problem. And I'm going to talk about that in a second. So part of this new legislation is provisions that talk about the county tax agent or the trustee replacing the private tax buyer. Now, there's some advantages to this. Number one being the private tax buyer is kind of works for us. They're going to make sure that the homeowner's equity is protected. They're going to make sure that the auctions are competitive and vigorous so we can get as much money for these properties as we can in an auction. And we know that because Joseph E. Meyer has been doing this for us for years. They get money, and they're in your packet. There's some statistics in there and what they've done. They have a pretty good closure rate of getting money for some of the properties that other tax buyers don't want. So they have a pretty good track record. Number two, county tax agent they get a lower interest than what a private tax buyer may bid out for. So the importance of that is that it costs less money for the distressed homeowner to redeem the property if the county trustee has it as opposed to the private tax buyer. Private tax buyer, and they were an important part of the process before Tyler because they were essentially loaning money to the county, and they were getting interest on that because they were paying the unpaid taxes. With the advent of Tyler, unfortunately, that process is no longer workable. Because every time a tax deed goes to a private tax buyer, it becomes a liability for the county. Because we're the ones that have got to make up for the lost equity, not the private tax buyer. So this is the statutory sections that talk about that. There's a downside, however, to the tax buyer being the county trustee. County trustee does not pay any funds for these property. No cash changes hands. So there'll be no annual tax sale for the taxing bodies to get some additional distribution based on the unpaid taxes. So there's going to be a little bit of pain initially from the taxing to the taxing bodies because they are not going to get that sliver of money that would typically be provided by the private tax buyers when they purchase tax certificates. Now, and then the county shares in that pain too because we don't get the distributions from that as well. But the school districts and some of the other places that are relying on this money, there's going to be a little bit of an impact in there. But the fact of the matter is that every time a private tax buyer takes a deed, that becomes a liability for the county and the county alone. So we have to keep that in mind when we're talking about this. So there's going to be some pain shared all around by this as a result of this United States Supreme Court decision. So I've already talked about some of the advantages of having the county trustee. And by the way, you would make the decision to do this. You would have to pass a resolution that would take all of the distressed properties out of the tax sale and essentially make the Will County be the buyer of these properties during the redemption period. And then the trustee would administer those properties similarly to what the private tax buyer would do. There's going to be more we believe there'll be some cost savings because there are lower interest rates that would be there. Also, there would be an elimination of a lot of the sale and errors. When a private tax buyer purchases a tax certificate, they can somewhere down the road make a claim with the court, oh, I bought this tax certificate in error. There was an error made in the paperwork. I did not realize there was a lien on this property. And that gives them grounds to get a sale and error. And a lot of times that sale and error comes with interest. So not only are we refunding their money that they bought the tax certificate, we are paying them sometimes a real high rate of interest on that money. And a lot of that would be eliminated with the county tax agent. Another advantage for the distressed homeowner is that the county trustee and the treasurer's office could take partial payments when the trustee, which they can't do with a private tax buyer. Private tax buyer, you got to pay the whole thing up front. There's no payment plans. That's it. Trustee is empowered under the act to take partial payments and work with the distressed homeowners. The downside of having, again, the county as the trustee and the tax agent handling this is that there is no private tax buyer revenue coming in from the tax sale. As I discussed earlier, that's the downside. That's a disadvantage to doing this, and I'm being upfront with what the trade-off is. So we at the state's attorney's office have the following recommendations for the board to consider. And the first one is we want you to pass a resolution that essentially makes the county trustee the owner of these distressed properties going forward. We think it's better, at least initially, to do it this way until we can get a process in place. We know how the auctions are going to be held because Joseph E. Meyer and Associates have been doing these auctions for decades. They know how to do it. They are already protecting homeowner equity. I had a case last week. The county tax agents already, even though it was purchased before the act, they're already protecting the equity of these homeowners. So we think that this is the better approach to go. Is there going to be a little bit of short-term pain as it works through? Yes, because there's not going to be any revenue coming in from the private tax buyers. But the fact of the matter is the costs are going to be lower. It's going to help the distressed homeowner, and we're going to make sure that the surplus from these properties is maximized. And we have control with that, whereas with the private tax buyer, we don't. If the private tax buyer do it, they have to also auction the property, but then the sheriff is doing the auctioning, and that increases our costs. Second recommendation is to pass a resolution authorizing the treasurer to collect a $20 fee that's been put into the act to help raise money for the surplus equity fund. And I believe there's going to be a resolution for that in August, which is important because there's going to be a bunch of payments made in September that we'd like to collect that fee on so we can start building up this fund. So that'll be for your consideration, hopefully be for your consideration this month. And we're recommending that you authorize the treasurer to collect that $20 fee that's been authorized by the act. And again, that money, which is money paid by the private tax buyers, that's going to go into the surplus equity fund, and that's going to go to help pay some of these back equity claims that we may owe. The third recommendation is that we're going to start a process trying to get the old outstanding tax certificates out of the old system and get them into the new system where everything's got to be auctioned. So right now, these 2,000 tax certificates are under the old system where they could potentially go in, get a tax deed, no auction, take the property, and then we get the bill. So working in conjunction with the treasurer's office, we're going to start a process where we're going to start trying to collect, bring those back in and get those under the new system. And we have a plan in place for that. It's going to take some work from the treasurer and from the state's attorney's office to bring that off, but we're dedicated to trying to protect the taxpayers in the county as best we can. And we feel that this is getting these 2,000 certificates out and into the new system where they got to be auctioned, I think is important in the long run. The last recommendation is that I think that the board is going to have to start making preparations to fund this equity fund. As the statute says, I'll answer any question anybody has. We need to start putting money into the equity fund. I believe if we do this in stages, and we're preparing for this, and I can tell you, from what I heard from the treasurer's office, from the treasurer's convention, we're on the cutting edge here. So we're ahead of the game in Will County. And I think that if we phase this in and we budget this properly, I don't think there's going to be a big impact, where I think some counties are going to take a serious hit. I can tell you, I've handled and settled 4 or 5 indemnity cases, and all of them went for $99,000 plus. And that's because under the statute, we have to pay $99,000 whether or not the homeowner was at fault in losing the house or not. That's what the statute says. So we pay that. In the indemnity cases that we've been handling lately, we've been getting waivers of any title or liability put right into the order. So anybody that's taken an indemnity award, that forecloses any potential filing a case or getting any money based on the Tyler case or the surplus equity fund. So we've been protecting it that way. Treasurer's office has also been notifying tax buyers over the past couple of years that there's potentially they're going to lose their equity, that they might be getting these tax certificates based on the Tyler case. So we've been trying to protect the county as best we can from this decision. But given that the property tax code is what it was until July 10th of this year, I mean, our options were limited. So, but the legislature has made the change, and they have made, they're now protecting the homeowner equity in their sales going forward, but we have to deal with the problem of the past properties, and that's where the surplus equity fund is. And I think we need to prepare for that because the storm is coming. I would like to manage it in a way that's to our benefit, as opposed to having a court judgment entered and saying, oh, well, county just pay this money. I've been trying to manage that through the indemnity cases as it is, and we've been having some success with that. That is the basics of what I came to talk about. I have the county agent, I have the treasurer here, people from the treasurer's office, and myself. We're prepared to answer any questions that the board may have on this subject. So I'll open the floor. Is that okay, Mr. Speaker?
We're gonna queue in to try to keep it organized. And folks, if you do have a question, maybe you could announce whether it's for the state's attorney, the trustees that are present, or the treasurer. That would be probably helpful. So the first 3 I have is member Newquist, Balich, and then Bullock. So member Newquist.
Thank you. I have a couple questions. First of all, I'm just a little confused about the $20 fee, collecting it from the tax buyers. If we're not going to have any more tax buyers, who are we collecting that $20 fee from?
Well, there's going to be payments coming in right now. A lot of these tax buyers have got to make the second payment. on the tax certificates they have.
Oh, okay,
So,
got it.
so when they come in to make a payment, that $20 fee is going to be tacked on to anything that a tax buyer comes in. And trust me, there are, as we have 2,000 certificates out there,
Yep.
potentially, we could be having 2,000 payments come in, and we're going to tack $20 that's non-refundable to each and every one of those payments. So
Okay.
that's why that's so important.
Okay, got it. And then my next question is, and I don't know if this is for you or if it's for the treasurer, like how much, if we implement this, going to the trustee, about how much revenue are we foregoing in the short run? I mean,
I think the treasurer can give a general idea.
On average, the tax sale brings in between $9 and $13 million each year. So approximately less than 0.5% of the total levy. Levy's about 2.4 billion.
but we're talking between $9 and $13 million.
right.
Okay.
And so that's spread across all the taxing bodies in the county.
Okay, and then the last two are just pretty quick, and I think they're probably for you, Tim. So funding, if we created this surplus equity fund, how much do you think we need?
It's hard to say. The incentive for the tax buyers that hold certificates now is to drag out that ownership of that certificate. The longer they hold it, the more their interest grows.
Right,
So if they just bought it last year, they may hold it. We're gonna ask them to come into the new system, but they don't have to. So if they drag it out, we may get more fees next year in the next payment, the first round and then the second round. And it's hard to estimate exactly what it'll do, but their incentive is to hold that longer
okay,
because the new law says they get their taxes repaid that they paid and their interest.
okay.
And every day means a lot of money to them because that interest is running at
Right, because they're
18%.
not getting the surplus anymore, they're only getting
Right.
the interest. But are we talking $10 million? Are we talking 1 million? I mean, any idea?
On the $20?
No, on creating the surplus equity fund.
Yeah, our liability will be way more than that $20 will ever grow
Oh,
to.
right.
Yeah.
Any idea how much though?
We've been putting our heads together, trying to come up with that number for you, and all we can give you is a worst case scenario.
Okay,
The worst case is year one, it might be 10 or 11 million dollars
okay,
that we're on the hook for. If everybody came in and sued us for that equity, that surplus equity that they've lost, and we had to pay it, it could be 10, 11 million dollars for a couple of years.
and then how far back can people go to make a claim? 2 years?
These are being filed under 1983, so the general statute of limitations is 2 years. But the federal courts really haven't sorted that out yet, so I don't want to speculate because there's a potential it could go back to 2 years before Tyler. And like I said, the class action is on file now.
Okay, so
So-
we're not talking 5 years or 10 years, we're talking.
Yeah, and the
relatively
indemnity is
short.
10 years. So, claims filed under the indemnity fund are 10 years. So
Okay,
it's going to take some period of time. I want to keep in mind, though, we've already kind of foreclosed some of these because if the people are taking the 99,000 in the indemnity fund, well, they're foreclosing the rest of the equity loss. So I have a list of the properties. That's where I got it from that. Some of the people that are on that list filed indemnity claims and they've been settled. So,
It's a court action.
right, it's a court action filed with the court. So when there was a judgment entered for the 99, they lose a claim for the rest of their equity loss, which sometimes is quite significant.
okay, so if they participate in that process, they can't participate in this process.
Correct. You cannot
basically.
double dip.
Okay, those are my questions. Thank you.
Thank you. Member Balich?
Oh, I thought got me on the third one. Okay. I have a question. One of the things that I see happen in 2023, the state of Illinois never did anything, so we have to file state law. So that's what we did. And then somewhere around Christmas, I don't remember the exact, last Christmas, I don't remember the exact date. There was a lawsuit in Cook County. And then the state said that Cook County people are following a different law, which isn't the one you're talking about. And so they have lawsuits now for all the back equity going back in time. And all those people are coming forward. And I don't know how far back in time they went, and I don't even know what the lawsuit number or none of that is. But I'm taking it from what you're saying is that we are liable the same as Cook County would be for all the back stuff that wasn't taken care of the right way, according to Tyler.
Well, I will say this. Cook County is different. And they look specifically at some of the procedures that Cook County was implementing. We did not do the same thing as they did. We were trying to be proactive. When this decision came down, I knew it was trouble. That's why we started getting the notices. We started treasurer was requiring to participate in the tax sale to sign off on an indemnity thing. Now, not everybody did it, but we got some people to do that in the event that they would have to indemnify us for the loss of the surplus. I was objecting to tax deeds. When I was in court, I was putting on the record, hey, there's this Tyler case out there and these people's home, surplus have got to be protected. So the treasurer and the state's attorney were trying to take some actions. And there's, of course, being court transcripts that we tried to slow down this process a little bit to protect us. I think that's going to differentiate us from some of the other counties that may be on the hook.
What we've tried to do is protect us from the future, but we can't control those individuals who may go into court and try to take some action. And those Cook County cases and others may serve as precedents for those actions. And you don't know what the judge is going to do. You don't know what's going to happen on appeal. And you don't know but in general, we've done the right thing. All our tax buyers were given notice right after the Tyler case came down. They were at least given a disclosure that says, this equity, that if you get this house 3 years from now, if you take it by deed, this equity that you're taking from that prior homeowner may be in jeopardy. We told them that. Then the next year, we asked them to sign it. There was no law that made them do that, but we asked them to sign it. And so we've done what we could do because, as you said, the existing law said I had to hold that tax sale. I had to do it. But so we're kind of in between. Until Illinois took this action, we couldn't do what we're asking you to do today.
So I had one other question for Scott. Seeing how is the state of Illinois refused to do anything about it, wouldn't have to be immediately, but 3 years, they've done nothing. Can we sue the state of Illinois for our damages?
I'm not going to speculate on some, obviously the state has sovereign immunity. So suing the state of Illinois, I don't know where that's going to go. In fact, I'm not going to say it.
Well, what I'm
My
getting at,
compatriots here do not want me to talk about my prior cases, but
No, but
there's a sovereign immunity issue that's going to
but
be
even with
involved.
sovereign immunity, if you take it to a federal court, you could probably sue the state for damages because they didn't obey what the decision was in 2023. I mean, I get it. They wouldn't do it in 1 month. It would take some time, but 3 years is too much time. So I think that we should even look into a federal lawsuit against the state of Illinois for not doing what they should have did back in 2023.
I will say this, we will take a look at that option. And if there's a route, and you can take my word at this, if there's a route for us to go, we're going to take it. This is what we do. If there's a route that we can take to make the state accountable, we're going to take it. Now, another option, possibly for your legislative committee, is to get the state to give us a grant to fund this surplus equity fund. That might be a legislative thing that the board can do and add it to its legislative agenda. Say, hey, you stuck us with this surplus equity fund. How about a grant to pay for some of this stuff? We'll have a little bit of a better idea. Maybe they create a grant process where counties can apply to the state and say, hey, look, we got these properties we want. So that possibility is out there too. So I don't know if, using a carrot or a stick would be the best approach on this, but certainly I think that's an option that can be added to the legislative agenda, and maybe that's something they will do.
See, that your option is a good option to help the county, but it doesn't help taxpayers because they're going to say, yeah, we'll give you a grant, then they're going to do a new tax to make us pay for it. So it's, it's a circle, big shell game, you know what I mean?
I
So-
understand it.
Yeah, so I like your, the $20 fee. I get it. It makes sense. And I have to think more about the other one, but I think it makes sense, but I got to make sure. So with that, Joe, can you make sure that you send this presentation on email to everybody on the board, including?
Yeah, absolutely.
But
It's
no, I
attached.
think you made a good presentation and it makes sense.
The PowerPoint is in the packet.
And it's on your agenda. And
Yeah,
if you want a
I look
separate
at it,
email, we can do
I
that.
read the agenda. I didn't go into the packet because I already had a good idea, because I've been studying all this stuff for probably 7, 8 months.
The packet has information about the trustee. There's a flow chart that's in the packet that talks the differences between what the trustee does and what the private taxpayer does. The packet for this meeting is quite informative. There's also something from the, it's at the UCCI. They did a summary of the law that I found to be satisfactory to give. It goes into a little bit more depth of what the statute is, and then next month or the next month or two, there might be some additional material made available to you that goes into detail about this as well.
Like I said, I think you gave a good presentation and the stuff makes sense what you're saying, so I don't have no argument with you, but I mean, look at the room. We have most of the people, but not all. So
Yeah.
I
When the more information is available, it'll be sent out to the board members. Yep. All right, thank you. Member Butler?
Thank you. So for preparations that are we required to fund this surplus equity fund? I heard $20 and then possible grants. What other preparations would be necessary to meet the 10 or $11 million liability?
Well, I don't know it's kind of hard to forecast what's going to come into the surplus equity fund in terms of the fees. Obviously, if we get that $20 thing, if we get that done this month and get that on before everybody comes in and makes their payments, that's going to help boost that fund.
But that's would hardly make a scratch.
40 grand.
10 or 11
Yeah,
dollars.
you're right. I mean, the fees are not going to cover what we're going to have. I acknowledge that. That's
So-
why I said number 4. We're going to have to set aside there's going to have to be some money that's going to have to be budgeted and put into this fund.
So does that mean that raising property taxes? I mean, what exactly I'm just curious as to what those preparations are, because, that's a lot of money.
It is, look.
It's probably something that this body needs to figure out. I don't know if the state's attorney should give his opinion on how to fund it.
Okay,
That would be up to the legislation. Yeah.
Okay, so then my other question is, does this new system that you're proposing prevent us from having to cover, this surplus equity fund for tax deeds?
So going forward, we're not going to have an issue. So we know, at least right now, we know where the end point is. We have 2,000 outstanding certificates. And we have a process and a plan in place to try to bring those back in and put those into the new system. The 70 or 80 tax deeds that have already passed, that's something we're going to have to deal with that. And I think the treasurer gave an indication, he thought possibly 10 or 11 million dollars based on the values of the property and the taxes that were owed, calculating on the properties that went out, that are currently held by private tax buyers from distressed homeowners. So those are going to be the funds, at least in the short term, that we may need to fund this equity fund. But going forward,
Well,
everything's going to be auctioned.
so you're saying to pay off this equity fund, we need maximum estimate 10 or 11 million dollars. And once we pay that off, we don't have that burden anymore.
The burden will be essentially taken care of. The only thing that I would say, and I want to open disclosure, If the auction, let's say somebody has a $300,000 home and they come in and nobody bids and the minimum, somebody comes in and takes the minimum bid for $30,000, theoretically, that would be something that somebody could make a claim under the surplus equity fund. That's why I think it's important to turn the process over to the tax agent who's had a very good track record of getting monies on the junk properties that they're stuck with in the tax sale. So they've had a pretty good job of turning low value properties into money. So I think it's better. That's why we're recommending that we follow the legislation path and take the tax buyers out. That, I think that increases the ability to avoid the future liability.
So just one last question for clarification. So when a land bank buys this property or takes this property and there's equity left, does the?
Well, I don't know, but this is not a land bank. We're not purchasing the property. When the county, when I say that the county is going to take the property, they're going to take the place of the tax buyer. So they're going to technically hold a tax certificate that essentially in 3 years, they'll be able to auction the property. So the homeowner will lose the property if they don't redeem. The trustee and the county is the technical owner because we will have the technical tax certificate. But we're not paying any cash for this. There's no cash changing hands. It's just that we're essentially going to be, for lack of a better term, we're going to be the holding agent during the redemption period while people have the opportunity to redeem.
Correct, but on these sales, if people are bidding on it and someone tried to bid $1 and someone said, that's crazy, I'll give you 100,000 for it. And another guy says 150, 200,000, and there's $30,000 in equity. The 30,000 gets paid back to the homeowner and you don't have it added to this,
Correct.
this liability. But if a land bank buys that property, they don't have the same responsibility, do they? They don't have to pay that. That's what I'm asking.
I mean, there's no land bank or anything involved in this process.
But I think, Dan, maybe
Yeah.
this will clarify. The trustees work in conjunction with the county. They essentially work for the county.
Correct.
So when we say the trustees will take over the deed, it's actually Will County.
Okay,
They do the work for us.
but this isn't, okay.
Yeah,
Does
nothing-
that help?
Nothing like that.
All right, let's
I guess I was missing the point of this whole presentation. I thought we were investigating all aspects of the land banks and stuff.
No, this has nothing to do, the land bank that ship has sailed.
Okay.
All right, thank you. Sorry, I turned you back on. Member Berkowitz?
Thank you, Speaker Van Dyne. Okay, so just to make sure that I completely understand, this new process is going to eliminate the private tax buyer. And-
If you pass the resolution.
Okay, exactly. Okay, so who is the trustee? Is the trustee, you've referred to the Will County trustee, is that Treasurer Brophy?
No. So what happens is, Neil, you want to come down here and introduce yourself a little bit? So as I stated during my presentation, at the annual tax sale, some of the properties don't get a bid. There's no bidding, so no private taxpayer comes in. Those properties still are still part of the tax sale. They go to our Will County trustee who we hire,
Who is?
pay, and it's Joseph Meyer and Associates.
Yes,
And Neil Wallace is the general counsel. Let me
Yes.
introduce and maybe explain a little bit how you.
thank you, Scott. Speaker and board members, the statute provides that the county board is the trustee for the taxing districts. We are Joseph E. Meyer and Associates is the tax agent appointed by the board. Frequently in conversations, we speak in shorthand. So we say, hey, we're giving it to the trustee because that's the easier way to say it. But you as the county board are the trustee. We have a contract to be the tax agent to perform the legal and administrative work on behalf of the county trustee because you all don't have time to go out there and post auction signs and such things. So We do that. We are the tax agent, but you are the county trustee and you will have the overarching control of this process.
Okay, so the definition of the trustee is the county, which I would assume falls in which department? The treasurer's department?
It is the county board itself.
The county board, so each county board member is a trustee.
No, the county board as a whole is the trustee for the taxing districts. And so then
Okay,
the statute allows you to appoint a tax agent to perform the legal and administrative work of that, because you are acting, anyone acting as trustee is acting for the beneficiaries of that trust. The beneficiaries of the trust are each one of all of the various taxing districts,
okay.
including the county.
Okay, thank you. I appreciate that clarification. So, Scott, let me just, I need to just kind of go through the whole process. Currently, this happened in our own neighborhood. Squatters moved in, the homeowner lost the property because they quit paying rent. No one would help us remove the squatters. And eventually the property owner lost their property because they could not afford to pay the mortgage. I even myself could not even get the squatters to answer the door. So that home, one day, the people were, the squatters were removed. Even though we asked everybody to help us remove them, it never happened. But the day the property owner lost that property, I guess it went into foreclosure, miraculously, those squatters were removed. They were gone. And during this whole time, of course, we have our minimal homeowners assessment dues. They weren't paying that either. Immediately after that property was finally vacant, there was a guy came in, demoed it or renovated it, and there was a for sale sign on that property faster than you could imagine. That house was sold for top dollar. The homeowner who lost the house, lost all their equity, got nothing from that sale. And we never got our assessment fees either. But the point is that homeowner, through no fault of their own, lost everything, and somebody made big bucks. So according to the way you've described it in that situation, in the current, who's making the money on the house when it's sold? The real estate agent gets a commission, I'm sure. Does the tax buyer then gets, if the whole house sold for $500,000, they get that whole $500,000. That's what happens today, right?
Well, you're talking about a mortgage foreclosure situation, which is not what we have here. This is a tax, banks, what people agree to in their mortgages, that's a completely different type of thing.
But it includes the taxes. So
Well,
if the,
Julie, like Scott was trying to say, if you were to purchase a home and you didn't have the cash, you got to go.
I understand that, but
So the bank would cover all of that.
So Scott, in that case, the county never loses any taxes? You're telling me that in those cases, the Will County receives all the property taxes that are due, yes or no?
Well, your example that you gave is not what we're talking about here. You're talking about a mortgage foreclosure that is covered by a different set of statutes and different rules and.
No, I'm just
But
asking,
in the
do we or
tax,
do we not?
in the
get
tax buyer, so currently now with the new act in place, because it's effective now,
Mhm.
that property has to be auctioned and the surplus goes back to the whole homeowner. Under the old system, if somebody didn't pay their taxes and a private taxpayer came in and took the property, if it wasn't redeemed, the tax buyer would receive the benefit.
Mhm. And that was under a statute, that current
Yes.
state statute.
Not current,
Okay.
it's old.
So,
It's been repealed.
So what I'm wondering, it was mentioned we have 2,000 of these properties. What is the equity value of those 2,000? And that might be a question for Treasurer Brophy.
10 to $11 million.
No, that's for the deeds. That's for the deeds. The 2,000 properties, we're not, I don't want to speculate on that at all.
Do we
don't
know?
have,
Do we know?
those are not. Finalized, they're in the system.
We should
Am I
know.
right, Treasurer?
We should have that amount.
Let's speculate, just so you know, worst case scenario maybe. The 75 to 80 that already got transferred, we're talking about are 10 to $11 million of risk that we may be subject to. So if you take the current 2,000,
Mhm.
assume that a lot of them are going to be redeemed and paid, the taxes will be paid, they'll never go to tax deed. If those tax buyers were allowed to proceed and go to take those deeds, and if it was the worst case scenario and you end up with 75 or 80 of that group, you'd have another 10 or 11, or with some inflation, 12 to $15 million at risk. Does that help?
Okay, and
Now, in the situation you were talking about a lender's foreclosure. So we have two different processes for people losing their home. A lender's foreclosure,
Mhm.
so the lender has first lien rights in many cases. If they don't make their loan payment, the lender can call the note due immediately, go to court, get an order, take the home, they hire the sheriff, evict the homeowner or who's ever in it. That was an eviction, a legal eviction. Now that lender takes title to the property. They can, of course, sell it, which they did. Buyer comes in, pays equity. At that sale, all our taxes were paid. So that's very different from a tax sale. In a case of a tax sale, there is no lender usually. There's no lender to get involved in foreclosing or kicking anybody out.
so Tim, what happens if the tax buyer, they hold that house as a private investment and they rent it?
Mhm.
Does the homeowner ever get any part of their equity back in that case?
In the old system, no. If they were successful in getting a deed from a judge, they took title to the home, cleaned it up, rented it out, that's theirs now. And the prior homeowner didn't get any benefit. Under the new system, yes, that tax buyer, if you don't approve our suggestion, and we hold a private tax sale like we've done in the past, those private tax buyers then have to hold an auction. And when they do, anybody can bid on it. A land bank would probably be outbid. Land bank is a member of the public too. They could bid on it, but they probably won't succeed. If it's of market value, some private owner will bid on it, take it, and put it back into play. Does that make sense?
So our target is that we need to have approximately 15 million or more dollars to cover these 2,000 properties because that's the home equity value.
That's a a wild guess at a potential
Okay, it's a
risk.
guess.
But we've got 11 on the old ones, maybe 10, 11 million, and maybe 15 million on the new ones. Yes,
Okay,
so
so do you work with the assessor? Because we all get reassessed and our property taxes continue to rise. So are you communicating with the assessor to make sure you're on top of whether or not this dollar is rising? Or do these properties, is there a hold on their assessments or their tax bills?
We're kind of really straying
Yeah.
apart of what we're talking about.
Okay.
I should-
I'm just curious because at the end of the day, that's, if taxes rise, then that means we have to, or property values rise.
your
I
risk
want to
is
make sure
greater.
that we do not have a risk.
Yeah, your risk is greater as prices rise.
Okay, and
We
that's
have a
something to
plan
consider.
to bring in the 2,000 certificates.
Okay.
We're going to, the treasurer and the state's attorney's office have a plan to try to get those back in.
Scott,
So-
how did you determine the $20 fee? How did you determine that it should be $20?
That's in the statute. That's in the legislation.
Oh, okay.
That's not, no determination there. That's what they said that we
Sounds
could
a
do.
little low. Thank you.
Okay?
All right. Member Oxley.
Thank you, Mr. Chairman. I was wondering if there's any move at the state for us to amend this, to change it back to where we need it to be. And then secondly, you know, we're talking about setting up a land bank. They have $1 million sitting there they have to spend. Maybe we should take that $1 million and put it in this fund to seed this program and move from there.
Thank you for your comment. Member Hickey?
Oh, hi.
Hi.
Okay. I apologize, Mr. Piles. I'm trying to wrap my head around all of this, but I looked at the trustee program impact summary, and is there any independent evaluation of that? Because that obviously came from Josephine Meyer. So I'm just wondering.
Well, I don't know. Are you talking like an audit?
I'm just wondering, are we accepting that at face value, or should we be looking into that more? I'm not entirely sure. I'm sorry.
Maybe the trustees can come up and explain how they come up with those numbers.
Gladly. In your packet, there's an impact summary
Right.
provided. So of course, we end that term, it's from 94 to 21 because the others are still active.
Okay,
But in that group, from 94 to 2021, 12,599 parcels that they handled, 99% of those tax dollars were distributed to the taxing bodies. So I think they've done a great job.
that sounds like a really, really good job. Can I ask how the contract is with Josephine Meyer? Is it like per parcel? Is it, I don't understand.
Certainly. We don't, I'm sorry, Whitney Strohmeyer, I'm president of Josephine Meyer Associates, and work with Neil. We've been, as that impact summary shows, we've been with you guys since 1994. We started, we're in 95, it says that on there too. We're currently in 95 of 102 counties. We don't charge the county or the taxing districts directly anything. We work on a commission basis. If we get the taxes collected, this percentage penalty that we've been talking about, Scott's been talking about, at a reduced rate now with the new statute, we get the penalty and the tax districts get all of their money, every penny, and all the fees are paid to every various departments and various fees, including this new $20 fee and that sort of thing. If it goes all the way through and doesn't get collected, those go to a surplus auction. This is the way we've always done it. And then we get a commission if and only if we sell that property. And that's how we get paid. And so it incentivizes us to do the work as best we can. That's why we're in 95 counties. We're very proud of that. Our process has always been compatible with the new statutes and this Tyler decision because of the way that we've done the process. So it's just kind of solidifying that for us, which is nice.
And I also want to say that the the trustee and the treasurer's office, the money or the surpluses from any sales that the trustee have handled since Tyler, we have. We didn't distribute that money. We were proactive and held on to it in case when the storm came, we've got the money.
Right.
So we're holding on to any surplus from anything that the trustees handled. So we're trying to be ahead of the curve here. And we took that action early on before the legislation was passed. Anything the trustee handled that we at least had some control over, surplus has been held and the treasurer hasn't.
Well, that sounds great. And I wonder what's wrong with the other 7 counties. That's all I have to say. Thank you very much.
Thank you.
Leader Richmond?
Great, thank you, Joe. Thank you, Scott. Thank you, Tim. And actually, Tim, if you don't mind walking to the microphone, so what I want to try and do is net this out for us. Tim, we've had conversations, you and I, as with the speaker and that kind of stuff too. 2,000 properties, and we're looking at potentially 75 to 80% for over the past 2 years.
No, 75 to 80 is a unit count of the number that have been sold.
Yeah, but that's over the past 2 years. That's the old thing.
Old.
Our conversations before, I believe we were saying that most of these get resolved in, let's just call it 95 to plus more percent.
Yep.
That does fall in line with our 75 to 80 number that comes out for the 2 years. So realistically, if we move things over to the trustee, that should resolve basically those 2,000. Those are taken off the table and those won't be a headache for us in the future.
Yes.
So really our focus is on the 75 to 80. And of those 75 to 80, the two variables in there is, do they have equity? And if they do have equity, will the landowner actually come in and want the money? So that's really our exposure.
Yeah.
Because if we take this action and we go and we move these over to the trustee, we should not have any major headaches moving forward. Our focus is on these 75 to 80. And I believe, Scott, you had said that you're also in, working those situations too, to try and resolve some of that. So, I mean, what we need to really look at is the potential equity exposure we have in that 75 to 80. And if there is any equity exposure in them, and we could maybe even assume that half of them, we won't have a landowner come forward and or an equity position in those.
It's really hard to tell,
I agree.
but it's a good evaluation you made.
Yeah, so I'm just trying to net it out for us as a board on where decisions need to be made I don't want to say don't worry about the 2,000, but historically speaking, 95, 96, 97, 98% of them resolve themselves.
Yeah. So this is a good scenario to account for. You've got some excess reserves that we've been enjoying from decent interest earnings. And it's a good idea. This is the occasion when you get a law like this passed you weren't aware of. This is why you have excess reserves. You can tag a lot of those to just be on hold for a while. It doesn't leave them there forever, but to be on hold in case we suffer losses, got the money to pay them. And after the storm clears, we'll get to a new normal. All the taxing bodies will be made whole again and everything will get back to normal. And then you can release the tag on those funds. Just a suggestion. The board can do whatever they want to cover this risk, but that's my suggestion.
Well, I mean, in the case here, we did have excess cash reserves in the past years, which is exceeding the norm. But in this case here, we do have it. And yes, reserves are meant to bridge gaps like this here. But to your point here is the fact that if we don't have that exposure, that money needs to be put back in to the right bucket because our exposure within 2 years and should be disappear.
Well, let me just add one thing. Keep in mind that the 70 to 80 that are out there are probably covered by the Sherritt versus Henry case, the class action that we are party to. So it's not really, in all honesty, it's not an if, it's more of a when. Because the chart, and I have a chart, that has these properties which you've seen. Those were turned over in discovery in Sherritt versus Henry. They're in play. So it's not an if with those, because the plaintiffs in that case are aware of those properties, dollars to donuts, there's going to be letters going out. I can tell you, I don't want to talk about it here, but there's a better than, a 90% likelihood that everybody that's on that list is going to be making a claim.
And some of them were, I'll call it scrap properties.
Some of them were, but the scrap properties those were on the trustees list. That was not included in the 70-80. The ones that are on the trustees list, we have the equity protected for those. So those are not really,
Okay.
that's not an issue for us. There's actually more out there because the trustees, hold on, the 70-80 are private tax buyers that have bought the property, have the tax deed. Residential homes. We're not talking about commercial here. We're only talking about the residential here, which is what the focus of the Tyler case was. So I want to keep that in mind. So as for the 2,000, like I said, we have a plan to bring those in. Are some of those gonna escape through the cracks? Yes, because the tax buyers do not have to turn those in. They bought them under the old system, and if we get fought, I'm going to fight them. I'm going to defend as best I can, but could some fall through the cracks? So you're right. I think that you're making the right assessment. I'm not right. I wouldn't completely forget about them.
No, I'm not saying we forget about them. I'm just trying to put a scope around our exposure here.
Yes. And like I said, we have a plan. We have a plan where we're going to deal with that. I think it's a pretty good plan. And if the plan works, then there won't be any exposure at all.
I like to hear that, Scott. Thank you.
Member Newquist?
Yeah, I just wanted to clarify on this one. Oh, there we go. Thanks. I just wanted to clarify in the 2,000, because you had said earlier, based on give me a worst case scenario, that out of the 2,000, we could potentially have another 70 to 80 that would fall under the old plan. So that would potentially be another, 10 to 11 million dollars. But now you're saying that if your plan works, that won't happen. We can take that off the table. But if your plan doesn't work, which, I have no reason to think it won't, we could, in theory, potentially have that additional liability, but at this point, you don't really have any way to tell.
Well, I don't want to, because I'm under instructions not to. We're going to do the best we can. I'll let our track record and these type of things speak for itself. But we think we have a good plan but I do want to say, there's a scenario where some of these properties, and if it's a really good property, they're going to fight. Because if there's $250,000 in equity on a property, they're going to fight. They're not just going to say, oh, okay, Piles wants to do this or the treasurer wants to do that. They're going to fight. So, and this is under the old system where they have a right at the end of the day to take a tax deed if they don't redeem. So you're correct in that the great majority of these are going to redeem, but you're going to see similar numbers to what we have now.
We've experienced, so in the usual case, you could guess at the average. Lately, we've had some activity in increased FOIA requests for this information. So there's new interest out there, parties that want to get a piece of this. So that's why we're so unsure of what will actually happen.
Okay, thank you.
Member Ogala?
So thank you. A couple of things. One, making the statement that we have cash reserves for something like this is not why we have cash reserves, because we never anticipated that we would have the situation coming before us. We have kept cash reserves because that's what you do when you have a government entity, and you keep that money from one tax collection season to another. I just want everyone to make it clear, we don't have cash reserves for this particular purpose. We can use it for this particular purpose, but we don't have it for this particular purpose. And then I do want to ask another thing. I'm assuming, and I don't know, that you guys have done a complete analysis of these properties, of what the equity might be in them. And then how is that equity determined? From the point of the fact that they didn't pay their first, second, third taxes years, or from the auction, or when is that calculated from?
So what we've done, or what the treasurer's office done for discovery in the Sherritt case, so it's not too difficult. We take the assessed value of the properties. So, and properties are assessed at 1/3 of what we think their market value is. So we times that by 3. So if a property is assessed at $33,000, that would make the fair market value roughly $100,000. So to determine what the equity loss would be, we take the amount of the taxes, penalties, interest, and everything that is owed. That gets paid. So if there was an auction and the property brought in, say, $60,000, and there were $20,000 in interest and back taxes and penalties, and the auction brought in 60, you measure the equity by the value at the auction, which was 60, minus the taxes, penalties, and interest of 20, leaving 40,000. Am I doing that?
Right.
See,
Hi.
hey, I should have been a math major.
Which you kept telling me you don't do the math, you only do lawyers.
That's correct.
My name's Julie Shatina. I'm the Chief Deputy for the Treasurer's Office. So I've been working with Scott ever since this law came into effect 4 years ago, in different various levels. We've been working on the Sherritt case together, and then now this new Public Act together. And because we're getting requests left and right for what we have on file for equity and things like that, I've done it on 2 forms. One, on the trustee level, where we have held back, and we know what we can see with the trustee level because we use the total redemption amount and any of the fees or costs or anything like that. And that's where we come up with what we would call the equity that we have put out. The problem is that on the trustee level, we can use that variable. We can take the total redemption amount and subtract off of that the assessment values, the market value, and whatever the difference is between what our assessor picks up as the market value and what they've collected at the auction. That's where we come up with the equity. Okay. So to answer your question about working with the assessor, we can only send information to them when things are not showing up on our sale and heirs properly. For instance, if the assessor picks up a property that shows a house and a tax buyer buys it thinking he's getting a house and it's a vacant lot, tax buyer can go out there, bid on it. He has no due diligence to say, I didn't know there wasn't a house on there. I looked at the property on the GIS maps. I looked at the properties. It showed a house. I put myself out there. The law does not say they have to do their due diligence. They only have to go to the tax sale and purchase it. That's all any of the tax buyers, including Joseph E. Myers. So when they have that, we have notified assessor saying, we got notification that the assessments are not where they're supposed to be. The pictures on GIS are not showing what they're supposed to be. And we can only do that. The treasurer cannot mandate the assessor to correctly do their properties right. We have to use those values to determine what the equity is, to be able to determine what their equity is on the trustee side. Now that's on the trustee. That's easy. That's an easy route for all of us because we can see it. They do the research. They're the title people. They go out there and look and see if there's mortgages. They go out there and see what's out there to determine equity. And they supply us with that information. Now, on the tax buyer side, we don't know what they do. Nobody polices them. They have to do it themselves. And whatever they are obligated to do as a tax buyer with this new law will determine what they do moving forward. But everything that we are on the hook for the past 2 years, we are taking I did the research. I went on the recorder system. I looked at what they sold the properties for. That's all we can use. There's where the equity starts. Whatever tax buyer sold their property that they took tax deed for, and there's $200,000, $300,000 sales out there.
they might have only had a redemption of $20,000. If we look at the sale price that they sold it for on the recorder side, take off the redemption amount, which is what the attorneys are going to do. There's your equity. That's what the taxpayer will get back. And that's what we are on the hook for at the county. That's what they are going to go to court, submit a document, and maybe there might be some fees or extra costs in there that they can prove. Under the old system, a mortgage company was not responsible for a tax buyer to pay. If there was a mortgage out there and the mortgage didn't redeem the taxes or didn't go out there and pay the taxes, they would have to file a judgment against the property owner themselves to get that mortgage, because the tax buyer is not on the hook to repay that mortgage. There are only certain liens that a tax buyer is on the hook for. Most of them are EPA liens. Those EPA liens where they buy a property that has tax, gasoline tanks in the ground and that, they're on the hook for. Anything that when the trustee gets, if there's anything that we cannot remove on the trustee side, if that lien goes with it, they put it in their catalog that goes out that the people can buy. We don't know what the tax buyers do. But all those properties that are on the list, those 75 properties, and anything moving forward that we attempt to try to get back from those 2,000, then the tax buyers know that they don't have to. Now, the court system, they were really good about giving them the capability to go in and say, we don't want to go through the whole process. We're going to file for a sale and error. And the court set it up that they can do that with interest. So they have every right to go in and do that. We may be challenged on our end because it didn't give us the opportunity to file an admin sale and error to do it. But we're going to try it, because the worst case that can happen, we're challenged. Scott will have to represent us. We'll see where that goes. And that's why we cannot guarantee out of those 2,000 what possibility we're on the hook for. But of those 2,000, we would have to calculate it the same way that we did those other 75. And that's by researching. For the share it, I had to give them information that what the market value was at the time we sold it and what the market value was at the time the tax buyer went for tax deed. The determining factor is when they went for tax deed. Some of the tax buyers deeded it back to themselves, basically, because they might have been a property management group or something. And when they went in and did that, they used their consideration cost of the redemption amount plus whatever fees, recording fees and all that. So technically on those cases, the homeowner has no way to claim any equity because there is none to claim. All of those cases will hit our indemnity fund because they can go after that $99,000 indemnity fund and say, well, the tax buyer either didn't sell it, it's still under his name, or there was no equity. And that's where Scott's going to get challenged with our equity funds too. We only get to collect, was it $20 for our indemnity? So our indemnity fund, if you looked at, we sell anywhere from 4,000 to 5,000 parcels, regardless if they go to the trustee or a tax buyer. Those fees is what we collect. That's not enough to pay out one case. So we have to use those too as consideration. Those are cases that the county pays back also, because we are obligated to pay them back interest if we don't have the money in our fund. So those cases are possibilities that can also be added to the situations that we presented today.
Thank you, Julie. That helped a lot. Thank you for that explanation. Appreciate it.
Thank you, Judy. Moving on to Member Bullock.
Hi, I'm pretty much with you on everything you've said. I just want to clarify. If I'm a tax buyer and I'm not a tax buyer, if I was a tax buyer and you reach out to me to try and move me into this new system and I say no, does that mean I still have the ability to get that equity out of the house because I was under the old system? Or does that mean either way, whether I go to the new system or I stay where I am, I have no more access to the equity of that property?
So under the 2,000 certificates that are still pending, those are under the old system. And yes, if, let's say, we did nothing, yes, they could get the equity. They could get the equity of that property. They're under the old system. But again, I want to reemphasize 1,800 to 1,900 of those certificates are going to be redeemed. They're going to pay. So we're really talking about a very much smaller number. Secondly, it's true that, you know, Julie kind of indicated what we're going to do a little bit. We're going to probably declare these as sale and heirs. And the sale and heir being that the surplus equity is for the distressed homeowner is not being protected. We're gonna run that up the flagpole and we're gonna see where it goes. So the treasurer's office is going to implement that. And if there's objections, no, that's when I'll get involved and, you know, in my usual way, I'm gonna make it that they're going to be better off taking the interest on the sale and heir because they will make money on their investment because they get interest on the sale and heir. I'm going to do my best to convince them that's the route to take. Take the money now as opposed to taking money several years from now after we've challenged it up on appeal and everything else that I have a tendency to do when people don't want to go my way.
So my motivation as a tax buyer is to get my money now.
Yes,
But-
take the sure interest now.
Because it could be years before I see anything. Is that
The headwinds are not with the tax buyers right now because the Tyler case is indicating that the people should be getting their money. The Illinois public policy now indicates that surpluses are protected. I think the headwinds are in our favor on that. And I think that the legislature has given an out to these tax buyers to make their money now.
Is there the ability on the county's part to get any percentage of that equity that the tax buyer got back to the homeowner?
There right now, in the Sherrod case, we've tried to file third-party actions, which are essentially asking the court, okay, maybe we did something wrong, but the tax buyer, as a third party, they received the benefit. We want them to help us out. And the courts have said no. Because they're suing under 1983, and there is no contribution from third parties in a 1983 act because the third party, the private entity, can't commit a 1983 action or violation. Only a public entity can. So that's the roadblock that we're running into. Could that get changed on appeal? It could. We think we've made some good arguments there, but right now we haven't getting a lot of traction on that. But we're trying some other avenues to try because this is a patently unfair that in Illinois, the entities that did the taking who received no benefit from the taking, now we're being asked to pay. And we really perceive that to be a problem, and we're going to advance it as best we can.
Member Balich?
Okay, I had a couple questions. Well, the first one, what you said, you know, it's not fair that we have to pay, but it's also not fair for the people that lose their houses that they don't get all their equity. So, you know, there's a double-sided coin. You know, does the government take the hit or do the people take the hit? You know, so, you know, that's kind of, you know, when you say it's not fair, well, in my mind, it's not fair to the people that own their houses that are losing their equity. So, you know, I don't even want to go any further with that, but what I wanted to find out, the $99,000 indemnity fund limit, that's from the old plan. And the new plan doesn't include a $99,000
No,
indemnity.
the indemnity fund is still in place.
It's in place. So
Yes.
what if the value of the house is over 99,000?
Well, they
Because
would probably make a surplus equity thing in instead.
surplus equity
You
suit.
can't do both. You got to choose.
Okay. And I have one other question. I'm writing this down. We got a lot of work to do to go over all this stuff, but I like what you proposed anyway. But now, the next problem that I see is what I was just listening to the thing, is that the way you determine the value of the house is what the assessed value is, multiplied by 3. So that gives you the market value. But, well, we got a problem in Will County with businesses like big box stores or whatever. We're under assessing them for a long, long time. Not all the assessors, but some of them. So let's just say a property is assessed for $100,000 market value. And then it's really worth $1 million. What happens to get all the money? So now they're going to go to a surplus equity suit if they just walked away. And so you're going to look at the difference. You'd have $900,000 that we'd be liable for. Is that
Well,
correct?
the Supreme Court did throw us a bone this last session. So the same folks that won the Tyler case went back to court, the Supreme Court, trying to say that the measure of damages for these losses should be the fair market value of the homes at the time the deal. Supreme Court essentially during the argument said, well, wait a minute, you're turning the county into a real estate agent. How does that fare? So the counter to that was that the surplus should be measured from an auction price. And the Supreme Court agreed with that position. So how they're being measured under Pung, which is the Supreme Court case, I think it's Pung versus Isabella County, how it's being measured now with the Supreme Court in determining what the equity is, it is now being measured by what it takes at auction. So under your scenario, we have to look at what the property fetched at an auction. You're talking about, well, properties are under assessed. We can't, there's no way to, anybody can go out and say
You
something.
answered it well. I mean, I saw a flaw and I'm glad I bring it up.
I'm sorry, what? Oh, yeah, Tyler only covered residential. And that's what we're dealing with. The commercial properties right now are not, if a business screws up and don't pay a bill, I don't think that's the same scenario as to somebody losing their personal home and their equity in their home. That's a different thing. There are different redemption periods. There are different rules apply. Right now, this is confined to the Tyler case. The Tyler case dealt with a residential property. That's what we're dealing with here now.
Yeah, I just figured it would work the same way, but you just answered the question. It goes to auction because if a property was misinterpreted as the value, it goes to auction. That tells you the value.
That's how it gets measured. Correct.
Okay.
Member Berkowitz?
Thank you. So this does not cover commercial or industrial properties.
Correct.
They will remain on going through the process we have today where they have tax sales once a year. Is that correct?
You handle it the same way. You want somebody from the.
And then
To answer your first question, all of the properties will go, under the proposal, all of the properties would go. And to clarify, I think the Pung and the Tyler case dealt with residential properties. Okay, that doesn't mean that those principles don't apply to commercial and industrial. that means that the Supreme Court cases that gave us these frameworks were residential properties. So to clarify that, but the properties that go delinquent are commercial, industrial, vacant, mineral rights. They run the whole gamut, and they're all included. And the treasurer has an obligation to sell all of them, and they're all going to go one of two paths, either private tax buyers or the county trustee.
So there's a choice, though. You just said they can go private buyer or trustee.
That's what's being presented is the state's attorney's office is recommending that the county board send all of the properties to itself as county trustee, and that they be prosecuted under that section of the statute. It's a separate section of the statute that allows for still an auction process, but it is a slightly different process, and et cetera, than with the private tax buyers.
So what is the financial burden to us if we take commercial and industrial properties and put it into the process you're proposing?
Well, there's not going to, I mean, number one, in terms of what the surplus equity fund, I don't want to speculate on that because we didn't look at the commercial properties. We're talking about a response to Tyler. Tyler dealt with residential homes. I think there are different interests at play with residential homes as opposed to business and commercial properties. So I don't want to go to the commercial aspect of it because the rules are different. The redemption period is different for commercial
But we're
properties.
focusing on the funds, the funds that we need to pay, the county needs. So we do need to understand what that number is. How much will the county have to pay towards these properties?
And you're asking about moving forward?
Moving
depending on
forward,
which-
correct.
So either process moving forward, the statute has fixed that liability issue. We're only talking about liability in the past. We have the 75 to 80 and then the 2,000 current open ones. There is no future liability on either path. The path you could choose to do the regular tax sale, the tax buyers will now, instead of just taking the equity, will have to go through the sheriff's office for a sheriff's tax deed sale. And the equity will be generated from that sale and paid to the property owner, industrial or commercial, residential, whatever. Or you can go through the tax buyer, tax trustee process, as opposed to the tax buyer. We'll send it to auction like we always have, and that generates the money for the equity. There is no liability in either situation moving forward. There's just the pros and cons that Scott talked about with added work on the county side, or you just send it over to us to do what we've always done. And the ones that we've done, there was never a liability issue anyway, because we always sent them to auction, and the treasurer's office has been holding that equity generated by those auctions since 2023, when the decision came down. So we're not talking about future liability. The auction will set the price and generate the money in either scenario moving forward.
I'm not talking about future liability. I'm talking about the liability we have today.
Okay.
And as we move forward into what you're proposing, what is the cost that the county needs to have in our reserves?
Tim?
Yeah. No.
Talking about the value of the 70 to 80 properties.
Commercial, industrial.
Commercial's not part of what we're talking about right now.
Okay,
And
so
very few commercial industrial end up in this situation because those are usually much more marketable.
can you tell
People
us
step
how
in.
many?
I
You
don't
said
know.
very
Do
few?
you have any commercial industrial that? can
I
point-
think, Julie, I think it's been stated
Yeah.
multiple times that
Okay.
it's
We can
commercial
move
and
on.
industrial is not part of this conversation. So just to.
Yes. Sorry, we didn't prepare any of that data because we're worried about homeowners. And as we said, the 75 to 80 may be a worst case liability of 10 to 11 million. And if some of the players in the 2000 group don't play ball, that might be another 15 million. So we're just worst case scenario, trying to give you a ballpark picture.
Fair enough. I don't see any questions from the board members. Do you want to make a summary or you want to? I guess moving forward, you're asking the county board for two things: a resolution to remove unpaid tax properties from the annual tax sale,
Yes.
and administer the county trustee, which is actually the county board, to
Yes.
administer, sorry. And then a second resolution to allow the county treasurer to collect $20 fee to generate money for the surplus fund from tax buyers.
That, and I think it would be a good idea to start making preparations to put some money into the surplus equity fund.
Okay.
If we phase it in, you may not have to even really do anything drastic. If we don't phase it in and we just get a judgment on the Sheriff versus Henry case, then, you know, we may have a different issue. I'm just saying preventatively, it'd be good to phase it in.
Okay, thank you. We have one last question from Member Ogala or statement.
Yeah, well, question. So you mentioned that we could phase it in. So what is the anticipation of how, let's say these properties come forward, what is the timeline we'd be looking at? And I know you don't have an exact number of thought, but how long would the process possibly take for them to go to court and ask for dollars back?
It's kind of in the planning stages to a certain extent because the legislation was just passed on July 10th and it's effective now. Legislation says that you can file court actions to get, if you are lost some equity, you can file a court action and the court will enter, you know, an award against the surplus equity fund. And the statute says that we have 12 months to fund it from that point. So how long those are going to take, I guess it depends on when they're filed and how long it takes to work through the court system and that.
This is entirely a board decision. Any funds you move into the surplus equity fund are not locked forever. They come right back out into your corporate reserve. So this is just your planning so that you're not making a move like in other cases where once you put it in, you can't get it out, like the the OPEB funds. Once you put them in there for retiree benefits, you can't take them out.
Right.
But this is not that case.
Thank you.
That's right. And in fact, if if we get some of these claims foreclosed or they don't make it, for whatever reason, once the crisis is over and there's money, then you rebate it or do something else with it. Yeah, you're not locked in. I'm just saying, I think we need to have a rainy day fund for this because I think it is coming. Let me explain a little bit of why I say that. So I'll give you an example of an indemnity case that we handled recently. So somebody lost their home in a tax sale by one tax buyer. And lo and behold, an attorney representing yet another tax buyer knocked on this person's door and say, hey, how would you like to keep your home? Of course, the person says, well, that's great. How do I do that? Hire us to file an indemnity claim. So then that tax buyer calls the other tax buyer lawyer and says, hey, they're going to file an indemnity claim. How about taking in you letting these people stay in their home, you take whatever we get from the equity claim. And they do that. These people work together. We're not talking about a large group of people and the tax buyers. They work together. They lobby together in Springfield. So, it's not random chance that some of this stuff happens. These people, and they got the Sherrod case, there's going to be claims made. There's going to be claims made. And I just think it's better to prepare for it, now. And then, then what that does, that gives me flexibility. If I know that I've got something, I can negotiate from a position of strength and I can get rid of some of these claims. I'm very good at that. And then that helps us out. Anything that I can do to shave a dollar or two off of something, I'll do it. And if I've got the flexibility to do that, and you give me that flexibility, it's going to work out. It's going to work out to the benefit. If we're in a position when we're not ready and the court just hands us a judgment, then I got no negotiating position at all. So I think that's I would like to be proactive. I think that we have tried very hard to be on the cutting edge of this, and I want to stay that way. I think it's worked out to our benefit. We've probably eliminated what? $500,000 in equity claims just by resolving the indemnity cases and getting the seal offs from the Tyler.
So I have another question. I know when Mary Tatro was here that she had us put money into that indemnity fund. How much do we have in there today?
We're paid. In fact, I've settled a couple indemnity claims because I'm trying to, as part of the settling, they got to release their Tyler claim. So I'm trying to be a little aggressive on those. We've settled 2 or 3 of those. I don't imagine there's a lot of money. There's about 100. Okay, I'm being told by the treasurer's office, there's 100 in there. Oh, 160, but didn't I just send out an order for one? Yeah, so they're,
Okay, I just knew we started one a while ago, and we didn't hear about these other situations till now. So, okay, thank you for
So,
that.
yeah, so for the record, 160 was in and there's a claim for 99,000. So 60,000 will be remaining. I don't know if anybody could hear that.
and I've got 2 or 3 open indemnity claims, so.
Okay. All right. Well, thank you, everyone that participated in this information. I'm sure the county board has some time to think about the decision moving forward. So no other new business. So the announcements by the chair